refused to fill some of the questions put to him by Mr. David Skhosana on the basis that the search and seizure warrant that was executed, sorry, I'm getting lost now, that was executed at his house on the 9th of October 2025 was amongst others occasioned by the criminal complaint opened against him by Mr. Skhosana on 10 July 2025. Chairperson, it is common cause that on the 10th of July 2025, and this was widely reported even in the media, Mr. Skhosana, a former member of parliament, a member of parliament representing the MK political party, opened a criminal case in Brooklyn against Minister Mkhwanazi, General Sphere, and others. He alleged that Mr. Mkhwanazi may have committed the offences of fraud, forgery, and defeating and obstructing the course of justice. It is also common cause that on the same day, Ms. Lisa Marie Shikeling, a member of the National Assembly and deputy spokesperson on police for the Democratic Alliance, registered a criminal case against Mr. Mkhwanazi. She alleged that Mr. Mkhwanazi may have committed the offence of fraud and the contravention of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act, which we abbreviate as the PIPLA. Screen is failing me. Sorry for that. So Chairperson, you've addressed 3 questions to us. One question is to a request for a written legal opinion on whether there is a reasonable apprehension of bias against the affected members. To be advised on the participation of the affected members in committee proceedings where such members have opened cases against witnesses, particularly on the issue of whether such members can put questions to witnesses. Furthermore, which is the 3rd question, Chairperson, you have requested to be advised that the legal implications of witnesses are before the committee under protest as a consequence of participation in the committee proceedings by the affected members. Chairperson, we briefly look at the regulatory environment, and of course, Sections 57(1)(b) of the Constitution provides that the National Assembly may make rules and orders concerning its business with due regard to representative and participatory democracy, transparency, and public involvement. Chairperson, we say the rules of the National Assembly are the rules envisaged in Section 57 of the Constitution, and Rule 30 of the NA rules deals with declaration of private interest. It is a requirement for members to declare their private interest in as far as Parliament's business is concerned. Rule 167F of the National Assembly rules provides that the committee may determine its own working arrangements. So, Chairperson, if you look at the Rule 30 of the NA as well referred to it above, implicates personal or private financial or business interests of members. And our view, Chairperson, is that the circumstances of the affected members do not fall within the purview of Rule 30 of the NA rules. The same is also true of the definition of conflict of interest found in Clause 1 of the Code of Ethical Conduct and Disclosure of Members' Interests for assembly and permanent council members, which we refer here to as the Ethics Code. So, Chairperson, we say that if you look at Rule 167F, that rule confers a wide mandate on the committee to determine its own working arrangements. The The implication of that is that the committee is at large to determine its own procedure in the conduct of its inquiry. Section 57, subsection 1 of the Constitution allows the National Assembly to determine in control its internal procedures and to make rules to do so. And Rule 167F is a default rule that allows the committee to determine its own working arrangements where no other rule provides otherwise. So we say that a committee that holds a public inquiry merely to report to the National Assembly in the performance of its functions does not perform administrative action subject to the rules of administrative justice laid down in part. However, Chairperson, we are quite wide awake to the fact that such a committee does exercise public power and is obliged to do so in accordance with the fundamental principle of the rule of law. And the most significant of those principles, for the purposes of this opinion, is the requirement of rationality. This therefore means that the committee has a wide discretion to determine its own procedure and ultimately to compile its own report to the National Assembly. And of course, the only requirement is that it must do so within the bounds of rationality. And this means that both its procedure and its report must be rational, and rationality is a low threshold for the validity of decisions, which require only a minimum standard of procedural fairness, substantive validity. So, Chairperson, when we speak about fairness in this context, we say that the committee will usually satisfy that requirement by observing the following rules. One, witnesses should be allowed to have their own legal assistance if they choose. Witnesses should be allowed to have their lawyers with them and with reason consult and take advice from their lawyers, as it happened with General Sidia. But that is as far as it goes. The committee need not allow the lawyers to speak on behalf of their clients at all. The evidence must be given by the witness and not the lawyer. We also speak about the fact that the committee should not, in its report to the National Assembly, make adverse findings against people without affording them an opportunity to address those findings. Shall we move to the legal test for bias or reasonable apprehension thereof? And we say, Chairperson, that the leading case here, post 1994, is President of the Republic of South Africa and others versus SADC, which is the South African Rugby Football Union. This has been, I think, well articulated, by courts, even in other matters like Bennett versus ABSA. And the principles are that the test is whether there exists a reasonable apprehension of bias in the mind of a reasonable objective. The fact that some aspects of these propensities may have been publicly articulated prior to coming to this court cannot, in my opinion, be regarded as anything more than a random circumstance that should not by itself form a basis for disqualification. Now, the Cape High Court recently has said in this regard, it is not bias per se to hold certain tentative views about a matter. It is a human nature to have certain prima facie views on any subject. A line must be drawn, however, between mere predispositions or attitudes on the one hand and prejudgment of the issues to be decided on the other. Bias or partiality occurs when the tribunal approaches a case not with its mind open to persuasion, nor conceding that exceptions would be made to its attitudes or opinions. But when it shuts its mind to any submissions made or evidence tendered in support of the case, it has to decide. No one can fairly decide the case before him if he has already prejudged it. So, with regard to the application of the test, the court in South held that the test for reasonable apprehension of bias is an objective one, as I have said, and that the onus of establishing it rests upon the applicant. Specifically with regard to proceedings of a lay tribunal, as opposed to a court composed of judges, the Supreme Court of Appeal has set out the governing principle as follows. The President is but one of the many cases in which an administrative body has failed to observe a principle which lawyers regard as elementary, and it will be a sad day if whenever this occurs, the body can be accused or suspected of bias. It is unfortunately one of the facts of life that administrative bodies perform their functions with varying degrees of competence. The mere fact that alteram partem was not observed does not by itself justify the inference of bias. In another case, Chairperson in the South African Human Rights Commission on behalf of the Jewish Board of Deputies versus Masuku and others, the Constitutional Court approved the following dicta and then made the following important observation. There must be an articulation of a logical connection between the matter and the feared deviation from the course of deciding the case on the merits. The bare assertion that a judge has an interest in litigation or an interest in a party to it will be of no assistance until the nature of the interest and the asserted connection with the possibility of departure from impartial decision making is articulated. And I think, Chair, in this regard, we say that an interest is a personal belief, goal, or commitment, while a conflict of interest is a situation where that personal interest potentially compromises your official duty or ability to act objectively. Having an interest is not inherently bad, but a conflict arises when your personal interest clashes with your official responsibilities, leading to a risk of bias in your decision making. Chairperson, we are required to advise as to the applicable test for bias in the particular circumstances of the committee conducting an investigation into the allegations made by Lieutenant General Mkhwanazi. In our view, the test is the same as that for any other lay body charged with making determinations of fact. Chairperson, as we know, the committee is a fact-finding body and must base its findings on the evidence presented to it and must provide reasons, therefore. Members of the committee may accordingly not bring to the fact-finding inquiry their own political views or biases, or those of the various parties which they represent. This is not to say that members may not have prima facie views regarding the subject of the inquiry. That would be an impossible requirement and would ignore the fact that most people, including judges, have predispositions which they bring to their legislative function. It is also a matter of public record that most, if not all, of the political parties represented on this committee have adopted a position one way or the other in respect of the subject matter of this inquiry. Provided, however, that they keep an open mind and reach their conclusions based on an honest and fair evaluation of the evidence placed before them. They are not per se biased merely because they or the political parties that they represent have taken such a view. Accordingly, our view is that the test for bias in the case of committee members is the same as that for other lay bodies, as set out above. The threshold for establishing bias is high, as we have already said, and speculative or subjective concerns are insufficient. In the premises, we hasten to opine that the cases that were opened by the affected members before the initiation of the subject inquiry do not exhibit bias or give rise to a reasonable apprehension thereof. In our view, a reasonable observer, if aware of these cases, would consider that they were registered before the commencement of the committee hearings. Such observer would also be aware of the fact that the cases were registered not in the context of the inquiry, but in the context of apparent contradictory versions made by Mr. Mkhwanazi, both in the public domain and before a committee of parliament regarding his association with Mr. Mkhwanazi. Moreover, it is the National Prosecuting Authority that will determine whether there are any prospects of success in prosecuting the said cases. They would also bear in mind the principles we have already referred to in respect of judges and lay persons regarding absolute neutrality. As long as the decision maker keeps an open mind and is prepared to be guided and informed by the evidence and submissions, he or she is not disqualified merely because he or she has articulated a particular view at some point in the past. Furthermore, we must point out, Chairperson, that the affected members are not the decision makers in this process. The committee as a whole deliberates on the evidence presented and then conveys its conclusions to the National Assembly. Consequently, we are not aware of any reason for the affected members to withdraw from the inquiry. For that reason, Chairperson, the affected members, like any other members of the committee, have a right to put questions to those witnesses they have registered cases against. In terms of Section 15 of PIPLA, a witness is not entitled to refuse to answer a question merely because the answer might incriminate him or her. Section 16 of PIPLA also provides that an incriminating answer may, however, not be used against the witness in such proceedings. Important, Chairperson, in terms of Section 17(1)(c) of PIPLA, a person who fails without sufficient cause to answer fully and satisfactorily all questions lawfully put to him or her under Section 15b, which deals with examination of witnesses, or to produce any document in his or her possession or custody, or under his or her control, which he or she has been required to produce under Section 15b, commits an offence and is liable to a fine or to imprisonment for a period not exceeding 12 months, or to both the fine and the imprisonment. Finally, Chairperson, those witnesses who appear before the committee under protest are entitled to assert their rights in a competent court as the judicial authority of the Republic of South Africa is vested in the courts. And Chairperson, we would just want to refer you to a full court decision of the Western Cape in a case, Public Protector versus Chairperson of Section 194 Inquiry and others. The case is a 2022 case, but it was decided or judgment was delivered in 2023. There, the Public Protector brought no less than 12 grounds of recusal. And the court chairperson said, we thus find, on the basis of in medias res, that it would not be appropriate for this court to permit a piecemeal review of proceedings. The court further said that the applicant retains effective remedies which remain available to her once the committee has completed its work. She has not shown the existence of grave injustice or that any harm which may have been suffered by her will be material and irreversible if the committee is permitted to proceed with this task. So chairperson, courts have been very low. This was a full court chairperson judgment. Courts have been very low, chairperson, to stop proceedings in medium res, in other words, in the middle of things or midstream. Chairperson, we so advise. Thank you very much.
Andile.
Yes, sir.
Andile.
Yes, sir.
So, what are the advices in respect of those three matters?
I thought I sketched them out, Chairperson, but I can repeat them. Because we're saying, Chairperson, if you look at the test, Chairperson.
No, not to look at. I think you have just presented, just to say, number one, this is the advice. If in all the three matters, the legal opinion says there is nothing wrong preventing members from participating, you just say no in all those three instances. This is what we are advising.
Yeah, but Chairperson, there's a rider to it in terms of honorable call upon that, because if you look at the terms of reference, Chairperson, you'll see that I think 4114 speaks about misconduct related issues for members of parliament. So it's only when the committee is seized with that that she may not participate in the proceedings of the committee. Otherwise, Chairperson, in summary, we say no impediment in those affected members participating in the Adhoc committee. Thanks, Chairperson.
Okay. May I request Honorable President Bath, because they have also sourced an opinion as the Democratic Alliance, if they want to talk to their legal opinion regarding Honorable Kola Barnett. Honorable Braden Bath.
She's on her way, Chair.
Oh, okay. You will let me know when she's about to start.
I'm here. Thank you, Chair. Sorry, I picked the audio off on my device because Honorable Kadabon and I are together, and I don't know how to switch it back on. So now I'm using her computer.
Okay.
Chair, yes, we have circulated our legal opinion, and I think it speaks for itself. I don't propose to go through it. The honourable members can read it at their leisure. Suffice it to say that the conclusion reached by the independent counsel from the Cape Town Bar, Mr. Michael Bishop, is that there is no factual basis to conclude that the Honourable Kola Barnard is biased, conflicted, or otherwise cannot participate in the ad hoc committee. Nonetheless, because the allegations against her are an issue before the committee, the National Assembly rules and the code require Honourable Kola Barnard to withdraw from the proceedings when the issues in paragraph 4.1.14 in the terms of reference is considered or decided upon, which she will of course do. So the bottom line is, Chair, that she's not required to withdraw from the ad hoc committee when any other issues are discussed, and it's therefore so that she will rejoin the committee, and when the issues that are in the said paragraph are discussed, the Honourable Kola Barnard will withdraw herself from those discussions.
Thank you so much. Are you done, Honorable Breitenbach?
I am. Thank you, Chair.
Thank you. And then, Andile, do you want to come back, or is it the senior counsel?
No, I'm done, Chair.
Yes, I wanted to check on the last item. Is it you or the senior counsel?
No, no, Chair, I'm done with my agenda items.
Okay. Senior counsel?
Good evening, Chair and honourable members. Chair, do you want me to comment on the two opinions that have been provided, or do you want me to move to the next item?
I want you to move to the next item of the witness list.
Okay. May I ask my two co-counsel to, with your leave, to address the committee on this aspect, and may I, again with your leave, Honourable Chair and Honourable Committee members, be excused from this meeting at about 8 or whenever the issue of the witnesses has been concluded. I obviously have a big day tomorrow and the next day, and lots of preparation ahead, Honourable Chair.
Okay, that is reasonable. Can we take the presentation?
Good evening, Chair, honourable members, the legal team and the technical team. It's Advocate Mkhwanazi speaking. Chair, we have basically two lists. One that we propose to run from after former Minister Bekele gives his evidence, which would be from the 28th until the 11th of November. And then there's a further list, which is a list that we've compiled witnesses that have arisen that we propose from the evidence that was led by General Mkhwanazi. So the list moving forward after former Minister Bekele gives his evidence, we propose to have Deputy Minister Matale. I'm sorry? May I continue? Is this? Oh. Chair, may I continue, or is this, or does somebody want to give a...
No, you can continue.
So, Chair, we propose to have Deputy Minister Matale as a witness from 28 to 29 October. 28 would be for an opportunity for him to be led, his evidence to be led, and then the 29th would be for the honourable members to be available for the honourable members to give their questions. And then on the 4th of November, we propose to have Deputy Minister Boshelo, 6th November, Acting Minister Kachalia, 11th November, the NDPP Advocate Shamila Batoye, and then 13th to 14th November, we propose to have Adhoc Advocate Anthea Johnson. Then there's a further list which we propose. There are no dates for those witnesses, and we haven't yet consulted with any of those witnesses. The list which I just mentioned, Chair, are witnesses that we have consulted with already, and we are in the process of finalizing their witness statements. So that's why we are in a position to allocate dates for those witnesses at this stage. The further list that we propose is Lieutenant General Kumalo, who is the project coordinator of the political task team, Lieutenant General Sentumule, who is the Divisional Commissioner, Detective and Forensic Services, the Chief of Staff of the Minister Mkhwanazi, Mr. Kabinde, and Mr. Brown Mkhwanazi. Then we have Major General Rabi, who is from the National Commissioner's Office. He is in charge of strategic management. And then we propose to have Brigadier Litoko, who is also from the Office of the National Commissioner. We also have President Cyril Ramaphosa on the list, but the evidence leaders at this stage, Chair, propose to that the request for information be sent to the President in relation to the meetings that were held with him and General Masimula and Minister Mchunu and also former Minister Bekitele. So those are the two lists that we have. Yeah. I don't know if my colleagues want to add anything to what I've just said. So I'll just give them an opportunity to comment on what I've said.
Evening, Chair. Evening, committee members. This is Advocate Lerato Zikalala. Thank you very much, Maria, for that presentation. I have nothing further to add to that.
Okay, thank you. Thank you, Senior Counsel. Thank you, Maria. Thank you, Lerato. Maria, just clarify the last name of President Ramaphosa. What did you say on that name?
The names that we had, of the people that he had meetings with, or the president's name?
No. The second list that you presented, you mentioned 6 names there of the generals, and the last name that you mentioned was of the president, but I didn't hear you properly. It's like you were saying you have sent questions or what?
Oh, so no. In respect of President Cyril Ramaphosa, we propose to just at this stage send him a request for information in relation to the meetings with General Masimula and Minister Mchunu. Note that Minister Mchunu's evidence is that the president approved. He had a discussion with the president in relation to the PKTT, and then we also proposed to ask the president about meetings or discussions that he had with a former Minister Bekitele. So the request went with those subjects.
No, that is very clear. And then the first list where you include Minister Kachalia, deputy ministers, is just a proposed schedule.
It's a proposed schedule that we were able to compile because, like I said, Chair, we already had consultations with these witnesses and we are in the process of finalizing their statements. But because In terms of the process that we follow, we would prepare their statements, engage with them to confirm that they're happy with the content that they approve, and then we will then confirm a date. So we're at the stage now where we're finalizing their statements, and we will communicate the dates with them if the committee approves this list.
Did you include IDEC and Advocate Patoi on that proposed schedule?
Yes, Chair. So maybe just to repeat the dates that we have.
Okay. No, it's fine. If they aren't included, it's okay.
Yes, we do have.
Maybe what I will suggest you do, because we still have a week coming, you can just have that schedule properly prepared, and we circulate it to the members tomorrow.
Will do, Chair.
Thank you so much. Honorable members, this is what we are going to do. We are going to discussions now. Let's take the discussions in this way. Dr. Tuli, in her presentation, okay. Dr. Tuli, in her presentation, gave us a schedule of the witnesses that are coming this week. And the senior counsel and his team have also presented a full schedule up to the 11th of November, of course, which they will update and make it available tomorrow.
Right. Board agreement. And this kid, you say it's yours. I'm only asking as most folks come through here are spoken for, especially little ones. People pay good money.